Thanks for joining us. This is Season 5, Episode 5 of Privacy and Data Today. And as the regular attendees will know me, Kirsten Thompson. I'm a partner in the Toronto office, and I lead our National Privacy and Cybersecurity Group with my practice focused on privacy and cybersecurity. Joined, as usual, by my colleague, Jamie Carty, Senior Associate in the Toronto office, whose practice also covers privacy and cybersecurity. So there has been a lot going on in the news. We will be talking about what happens to privacy now that the election is over. And Jamie, who attended the IAPP Canada Symposium, will give us a few updates. In the regulatory and legislative update section, the BC Privacy Commissioner secured a very rare court order to enforce some FIPPA obligations. And the Quebec released some new guidance on handling personal information in the context of recruitment. Litigation, it's been a very busy season for litigation. There's 4 cases we'll discuss. The one that's caught everybody's attention is that a portion of Alberta's privacy law was struck down as being unconstitutional. Newfoundland courts are swinging back and forth about whether or not a privacy tort exists there. A BC decision that was very recently, instead of following national trends, is now skewed off in the other direction. Saying that class actions can proceed even without proof of damages. And finally, another BC decision where the court said that, well, privacy commissioner reports are admissible, they cannot be accepted as evidence for proof of the truth of the contents. So with that, let's kick it off, and over to you, Jamie.
All right, so we'll start by looking into our crystal ball a bit about what we can expect in terms of privacy reforms now that the election is behind us. By way of a brief modern history lesson, Parliament was prorogued this past January, and with that, 3 significant bills in the privacy and cybersecurity space died on the order paper. The first of those was Bill C-27, of course, which would have enacted the Consumer Privacy Protection Act, repealing and replacing Part 1 of FIPPA. It also would have enacted the Personal Information and Data Protection Tribunal Act and the Artificial Intelligence and Data Act. Now, that bill had made it past second reading with the House of Commons and was before the Standing Committee of Industry and Technology when Parliament was prorogued. Second, we have Bill C-26, I should say had, Bill C-26, which was the Critical Cyber Systems Protection Act. And it was actually the furthest along in the legislative process. It had been through the House of Commons readings, seen by the Senate, and sent back to the House of Commons with amendments proposed by the Senate when Parliament was prorogued. And lastly, we had Bill C-63, the Online Farms Act, which had reached second reading at the House of Commons. So all 3 of those died on the order paper. And on March 23rd, that snap election was called, with the election being held on April 28th, following which the Liberals secured their minority government. So what's next? Truthfully, it remains to be seen whether these privacy and cybersecurity reforms will remain a priority for the Liberal government, given everything else that's currently going on. However, assuming that some reforms do take place, given that the incumbent party is the same as the last, we anticipate that any future proposals will be aligned with what the last Liberal government had tabled, although likely modified slightly to reflect lesson learned about what would receive broader support. So, for example, we still anticipate and hope for a bill modernizing the federal private sector privacy law, FIPPA, but expect that any proposed artificial intelligence legislation would be tabled separately from that bill. And that's because ADA's inclusion in Bill C-27 garnered a fair amount of controversy, particularly because it was included in there without any prior consultation. We do expect there to be some movement on the AI front, and that's largely signaled by last week's creation of a new cabinet position, the Minister for Artificial Intelligence. And you may recognize the name there, Evan Solomon. I think he was a CBC reporter or something similar to that. Anyways, the creation of this new cabinet position signals the federal government's ongoing interest in artificial intelligence and perhaps its intent to make this a priority area. While the last version of the Federal AI Act, being ADA under C-27, really was just a high-level framework that had long voluntary compliance periods prior to which it would have eventually come into effect. We hope that this new dedicated minister's position may mean that any new AI bills would be more ambitious, not only in timelines, but also in terms of providing clarity about what's going to be required by organizations involved in artificial intelligence. And also just sort of anticipating a bit of a Brussels effect in that any new AI bill may largely parallel what we see in the EU AI Act, which is now in effect over in Europe. Moving on to any bills proposing protections for critical infrastructure. As I mentioned, Bill C-26 was pretty close to the finish line there, so it could very well be tabled in a very similar form. On the other hand, the current political landscape is quite different than the political landscape that we had when C-26 was initially drafted and tabled. And so given that, we may see that even more thought is being put into how to best protect our nation's critical infrastructure. And finally, with respect to online harms, if a similar bill is tabled by this new government, we do expect there to be a slightly more targeted approach to the next iteration, given the concerns that were raised about Bill C-63's effects, not only on free speech, but also on the burdens that it may have placed on the Human Rights Commission's complaint system. So just a bit more of a thoughtful, targeted approach in any future online harm proposed bills. Kirsten, over to you.
Thank you. Those of you that have been following the news will know that the Toronto District School Board recently sent out a letter advising families that despite paying a ransom, the threat actor involved in the Power School breach did not delete the personal information as promised. So if you recall a while back, the Power School, which is a provider to various educational institutions, was hit by a ransomware attack, and they paid the ransom. But the bad guy still posted the information. So now various school boards, including the Toronto District School Board, are advising families. This highlights a new direction in ransomware that's been evolving. So there are really two types of ransomware. That's the kind where you pay and you get your systems unlocked, or you pay and then they promise not to publish the information they stole. And then there's a third sort of hybrid where they hit you twice. So they want you to pay and get your systems unlocked, and they also want you to pay not to publish. Surprisingly, there's no honor among thieves. Just because you pay doesn't mean you're necessarily going to get what they say. There used to be a fair degree of honor among thieves. It was a pretty standard business model, and if you don't honor your word, then people will no longer pay ransoms. Organized crime understood that. But law enforcement raids have significantly disrupted the universe of bad guys. So now we have freelancers, rogues, various entrepreneurs, loose cannons, et cetera, no longer the honorable thieves that we used to have. So just be aware that that is a factor now when considering whether or not to pay ransom, particularly to prevent publication. And I saw a headline this morning that a 19-year-old US college student has agreed to plead guilty to that particular hack. We're going to head into the regulatory and legislative updates, followed by the litigation. We're going to break this up a little bit. Rather than ping-ponging back and forth, Jamie is going to talk at length about regulatory and legislative updates, and then I'm going to talk at length about litigation. So, Jamie, over to you.
Great. Okay, so for those of you who weren't at the International Association of Privacy Professionals Canada Privacy Symposium, that's such a mouthful, conference last week, on the very first day of the conference, Commissioner Dufresne of the Office of the Privacy Commissioner of Canada announced that his office is launching an exploratory consultation that will help inform the development of a children's privacy code for Canada. So in particular, the OPC is inviting parties such as children, parents, guardians, educators, private sector organizations, really honestly, it seems like anybody, to contribute their thoughts and ideas to ensure that such a code reflects the best interests of children. The consultation is going to explore creating clear, practical guidelines for organizations that handle children's personal information. And the accompanying news release from the OPC was suggestive of a privacy by default expectation being imposed on these organizations. Now, obviously, it's early days, so it remains to be seen what type of guidance will ultimately be included in this code, but just sort of putting that on the radar now. This consultation builds on the OPC's past work to do with children's privacy. It's really been one of the strategic pillars, focus areas for the OPC and provincial regulators over the past couple of years. So some of that past work includes the G7 Data Protection and Privacy Authority's statement on AI in children, as well as past resolutions that have been jointly released by the OPC and its provincial and territorial counterparts on the best interests of young people and also deceptive design patterns, which we've spoken to in past webinars. The future implementation of a children's privacy code will also be aligned with similar initiatives that are taking place globally, most notably in Australia and the UK. So the OPC is accepting submissions or feedback by email. We will include some of that information in our post-event email that gets circulated, just in case anyone on this call is interested in participating. A few other notable highlights from the symposium last week. Rick Mercer delivered a keynote address, which was hilarious. I have to say, it is not easy to speak to a room of 1,000+ privacy professionals when you yourself are not a privacy professional. But he had me in tears at one point because I was laughing so hard, and he just had the whole room enthralled. So not really relevant to privacy, but a fun tidbit. There was a fair amount of discourse on not being the office of no. And I think as legal counsel, probably particularly in-house legal counsel, but also external counsel, we often find ourselves in the position of having to say no to business units and their ideas. And I guess the theme is that privacy professionals are now also increasingly finding themselves in that position. And the theme here was really to get integrated from the start. So work with your business units, work with your teams to really embed privacy as a foundational principle in any new initiatives, such that you're not consulted at the last moment and put in a position where you have to be like, no, we can't do any of this. So that's, I guess, something that people are really coming up against a lot. And there was some creative ideas for how to better integrate privacy professionals and legal counsel from the outset. There was also a lot of discourse around, children's privacy, as noted with the code, but also the need to harmonize between federal and provincial laws, as well as those across borders, and just sort of an acknowledgement that the complexity caused by all these different requirements that are emerging, like we think about the states and how they have a state-by-state approach, not only makes it very difficult for organizations to find themselves in a compliant position, but also incredibly expensive. So there was no real answer here. It was sort of just like old man yelling at a cloud about the state of things, but definitely an acknowledgement around the difficulties that are arising as different jurisdictions enact similar but slightly different requirements in what's expected from a privacy perspective. Okay, I'll move on to some updates from our provincial privacy commissioners. The Office of the Information and Privacy Commissioner of BC obtained a court order this past month to enforce obligations under that province's Freedom of Information and Protection of Privacy Act. Specifically, this matter arose when the Northern Health Authority failed to respond to an access request regarding conditions at a long-term care facility that it operates. When the legislated timeline for responding had lapsed, the requester filed a complaint with the OIPC, and the OIPC launched an inquiry into the matter. During that inquiry, the requester and the Northern Health Authority signed a consent order, pursuant to which the Health Authority agreed to provide its overdue response by a certain date. That date was April 22nd, and that date came and went with no response from the Health Authority, which is not honestly that uncommon. People or organizations do miss their deadlines, but what was uncommon was that the OIPC took the rare step of filing that consent order with the BC Supreme Court. And now that that order has been filed with the court, the OIPC is able to enforce it to the same effect as if it was issued by the court. And this could result in a finding of contempt of court if the health authority continues to refuse to comply by issuing an access decision. So this is not something that we often see from our privacy commissioners, but the action is honestly it's pretty well aligned with BC's new commissioner's track record for a more aggressive enforcement of his office's mandate. So we may expect to see more of this type of action from his office over the remaining 5 years on his 6-year term. And maybe it'll have a knock-on effect and encourage other privacy commissioners to be similarly aggressive in their enforcement. We'll skip over from BC to Quebec. As Kirsten mentioned, the CHI has added a new page to its website, which is dedicated to the collection of personal information in the hiring process. Now, as is customary for the CHI, this new webpage is offered in French only, but we do have a really helpful blog summarizing the guidance, which we will circulate in our follow-up email. In the guidance, the CHI emphasizes necessity as a key criteria for collecting personal information when hiring. And it elaborates on the types of information that may and should not be collected at the various stages of the hiring process. So I'll just quickly go through this to sort of give you like some high level notes and give you a sense of what this guidance offers for organizations. So you've put out a job ad and you're now receiving applications. The CHI advises that at this stage, employers are generally only permitted to request and collect personal information that's necessary to assess whether those applications are eligible for and express an interest in the position being advertised. So that's quite narrow. The CHI at this stage specifically recommends against obtaining any references and also using any sort of template application forms, because both may result in an over collection of personal information that's not necessary. When you find yourself at the stage where you're evaluating applications, the CHI advises that employers can request ID to confirm an applicant's identity, but they shouldn't be retaining any copies of those IDs. Employers should also not collect any information relating to protected grounds under the province's Charter of Human Rights and Freedoms, unless that information is objectively required by the nature of the position being advertised. When it comes time to confirm an applicant's skills and abilities, so this is after an interview has taken place and a conditional job offer has been extended, the CHI says that at this stage, employers can ask for references and consult those external files about a candidate. But the guidance does set out certain guardrails for engaging in this sort of consultation process. First, employers should limit any consultations with social media unless it's necessary for the position in question. And even then, they should limit those consultations to professional social networks. So checking LinkedIn, likely fine. Checking TikTok, probably not. Second, the CHI's position is that more sensitive consultations, so things like credit checks or medical checks, criminal history checks, etc., should only be conducted where they're objectively justified for the position. And lastly, we're at the point where you are hiring someone. You are signing that employment contract and onboarding them to your company. The CHI says that this is a stage at which collecting additional personal information, such as a candidate's residential address, their emergency contact information, their birthday, SIN, bank account information, etc. This is the stage at which that sort of collection would actually be necessary. And that's not only for affecting the employment agreement, but also administering that employment relationship. So ensuring that you can pay them, administer benefits, etc. So this is issued by the CHI in Quebec, but really it provides some pretty excellent guidance for organizations across the board and really thinking about what type of personal information they're collecting from job applicants at every stage of the hiring process. So it's worth taking a look. And with that, I will pass you off to Kirsten for some juicy updates on the privacy jurisprudence.
All right, litigation. Everybody is suing everybody. Well, actually, what's happened is people sued people a long time ago, and now it's finally, after 6, 7, 8 years, finally getting through the courts. So we'll start in BC, and this is the long-running saga of the Insurance Corporation of BC, which is the provincial insurer, known as ICBC, and ARI. And if you recall way back, there was an employee at ICBC that pilfered a bunch of insurance claim information, sold it to motorcycle gangs and organized crime, who then promptly shot up individuals' houses and set things on fire. So data breach is bad, people. Class action was launched on behalf of the employees that were affected, and claims and insureds that were affected, and their relatives who, also lived in the houses that were being shot up and burned. Privacy claim, back and forth it went. And really this case has now hit the appeal court, and that's the decision we're talking about. And it's interesting because it really asks, how much is privacy worth? And the interesting part of this is that it's about damages. And the real question before the Court of Appeal was whether or not general damages can be awarded for breach of privacy without proof of consequential loss, i.e. Hurt feelings, and stuff that you don't have a receipt for, rather than just nominal damages. And the critical distinction here is this was a claim under the Privacy Act, which is statute in BC, and not the intrusion upon seclusion, that common law tort that originated in Ontario, Jones and CJ. In that case, in 2012 now, They said, okay, breach of privacy under the common law, you should probably get damages to understand, to compensate you, but they should be nominal damages. And so we've seen intrusion upon seclusion claims are quite low. But under the Privacy Act, which is again, the BC statute, not BC FIPPA, but the Privacy Act, the court said, well, no, breach of privacy is a thing unto itself. And we need to recognize that. And so more than just nominal damages. So the Privacy Act creates the statutory tort. And the first line says, it is a tort actionable without proof of damage for a person willfully and without a claim of right to violate the privacy of another. And that was the claim. Poor old ICBC got dragged in here because it was vicariously liable for the employee who was a bad actor. The plaintiff sought non-pecuniary damages. Remember, those are the ones you don't have receipts for $25,000 for breach of the Privacy Act, and then said, well, if people have receipts, you can pay more for those things too. ICBC, not surprisingly, said, whoa, no way, that's too high. Baseline damages for hurt feelings should be like $500 per person. So there's a big swing between $2,500 and $500. The lower court said, you know what, we're going to go with $15,000 because this is more than just a nominal award. The Court of Appeal dismissed the appeal, affirmed the lower court, and said, yeah, you know what? We recognize two things here. There's a plaintiff's privacy interest under this statutory tort, and we're going to compensate you for that. And that's more than just nominal. It's independent from damages for mental distress or any upset related to the breach. So what does that mean? You now, there's a potential for some fairly significant damages in BC under the Privacy Act. Bad news, 4 other provinces have similar acts. Now, the circumstances in the ICBC and Erie case were pretty egregious, but just understand that that door has been opened. Moving on over to Alberta, Clearview AI, the never-ending saga of Clearview AI, and this time took on the Alberta Privacy Commissioner. And this was related to Clearview AI scraping images and associated data from publicly accessible online sources, the internet, like Facebook and LinkedIn, company web pages, and so on. They converted these images to biometric identifiers and then basically provided a facial recognition service to law enforcement. Privacy commissioners across the country getting involved in an investigation. They published a joint report. They found that Clearview AI needed consent to collect people's faces. Clearview said, no, this was publicly available information that people had voluntarily posted, and therefore it was free to use. They pointed to an exception specifically for this in privacy law regulations that essentially said that if information was publicly available, you don't need consent. Privacy commissioner said, no. Publicly available is actually defined, and it means the personal information is contained in a publication, including but not limited to magazine, book, or newspaper, whether in print or electronic form, but only if the publication is available to the public, and it is reasonable to assume that the individual that the information is about provided that information. Clearview said, yeah, it's a book of faces, and it's in electronic form. Privacy commissioner said, nope, online sources aren't included. Joint report was issued. Alberta Privacy Commissioner, because it has the power to do so, issued an order. And in that order, it ordered Clearview to basically stop doing business in the country, well, at least in Alberta, cease the collection, use, and disclosure of images and biometric facial arrays collected from individuals in Alberta, and delete anything that you've collected. In response, Clearview said no, and applied for judicial review of the order on the basis, among other things, that the OIPC had adopted an unreasonable interpretation of this publicly available provision. Court agreed with Clearview on that, saying that, well, the Alberta Privacy Commissioner's interpretation was reasonable on its face. That interpretation unreasonably limited freedom of expression under the Charter. And so it found Clearview had a right to freedom of expression, and that included this broader commercial right. The fix was to strike out some language in the middle. So that phrase that I read you before now would read, the personal information is contained in a publication, whether printed or electronic form, but only if blah, blah, blah. So now this, the court has given publication its ordinary meaning, which means something that's been intentionally made public. Now, no big win for Clearview, because the court did affirm the Privacy Commissioner's finding that Clearview's purpose was not reasonable, and so the order was upheld on that basis. But what does this mean? It's significant for broadening what we consider to be publicly available information. Now, the case is limited to Alberta, but there are similar language is used in a bunch of different statutes, including Alberta, BC, and the federal statute. So I expect legislators and drafters will be reviewing that. The purpose of the collection will still matter. It doesn't mean you can run around the internet collecting a bunch of information willy-nilly. You can't. The purpose will matter, and that's ultimately where Clearview failed. So keep an eye out for a legislative response on this, but there's a lot of companies that are looking at this as freeing up a lot of uses of information. For those of you that are concerned about this, time to get everything off the internet. Back into BC, long-running case, Cadillac Fairview. Recall way back in 2018, Cadillac Fairview was accused of embedding facial recognition software in its wayfinding directories, those little kiosks with maps. And privacy commissioners investigated that. They found, again, another joint report, and they found that despite evidence of the anonymous nature of the information being processed, i.e. no facial recognition was in use, that CFCL was nonetheless creating over 5 million unique biometric identifiers without notice or consent, which it needed. Cue class action. Plaintiffs sued in BC and Quebec. Quebec action was stayed in preference to the BC, and then just a week and a half ago, BC declined to certify, and the certification was denied across the board for all claims. Notably in that decision, it's notable for dismissing all the claims, but it's also notable for a paragraph that says, I accept that the OPC report is admissible, but not for the truth of its contents. As such, I cannot rely on its findings as evidence that Cadillac Fairview collected images and biometric information without consent. So this is a pretty definitive statement that, well, the OPC reports and findings are admissible, they're not necessarily going to be taken as true. This matters because historically what happens is the OPC investigates, publish a report, and then plaintiff's counsel immediately start a class action, and their evidence is the OPC report. This puts a significant dent in that approach. And then one more out of Newfoundland, Newfoundland Court of Appeal. And I encourage you to read this one because this is full of small town drama and intrigue. There is a chief administrative officer there, but we'll call him the mayor. He took a leave of absence for workplace harassment complaint. Unfortunately, he left his account connected to his city-issued iPad. Messages kept popping up, showing he was having discussions with counselors about the matter. The counselors were subsequently removed and lost their seats, vacated their seats. A fight broke out on a number of different fronts, but he claimed that the city had breached his privacy, both under Newfoundland's Privacy Act, there's that Privacy Act again, and the common law tort of intrusion upon seclusion. So the lower court found that both exist and he was entitled to recover. However, and this had been the case for about 2 years, the Court of Appeal reversed and said, no, there's no need to introduce this common law tort of intrusion again. At best, it was unsettled. By the way, it's only the Privacy Act. So that's where we are. We continue to go back and forth on this. I see we are at time, so I thank you all for joining us. We have one more session. We'll see you again in June, and then we are off for the summer break, and we hope you are too. Thank you very much.